Where it stops, no one knows. We're going headed into the unknown. Na, 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 na.
Hello, 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 and happy Monday. I hope everybody enjoyed your weekend. And if you didn't catch the live last night, make sure to go back and hit that on replay, because there was definitely some laughable moments going through the motion to dismiss. So let me say hi to everybody. We're going to actually be going over the state's response. So as many of you guys know who've been here for a while, like, welcome back, obviously. And if you're new here, welcome. But on the 18th, the motion for contempt, I can't even talk today. Probably shouldn't be doing this. The motion for contempt was held, and Judge Gold gave the defense 1 week to do a post-hearing memo. And then 1 week from that, she gave the prosecution a week to do a post-hearing memo. So here we are, another week out from that hearing, and we have the prosecution's reasons that they believe that Andrew Baldwin and Bradley Rosie should be held in contempt of court. Last week we read through Hennessy's response, so if you missed that, make sure you go back and listen to it. So I'm gonna say hi to everybody, and then we're gonna get started, because I don't know if this is gonna be a super long one. It definitely won't be like the 4 hours. I don't think we have that much to go over. So let me say hi, Stacy. Hi, Carla. What up, four pit bulls across America? Hi, Just Deb. Hi, Mother of Dragons. Hi, Kaylee. Hi, AH. Unsolved Christery. I can't. That one gets me tongue tied every time. Unsolved Christeries. Hi, Terry. What's up, Kathy? Hi, Miranda. What's up, Susan? Hi, Laura. Snappy Dragon. Journey takes a trip. Hi, Terry. Hi, Brian. Good to see you. Hi, Hunting Evil. Hi, Tony. What's up, Carla? Hi, Hoosier Heather. The Sniper. I was talking to you in chat. Salty C, 20 months. OG right here. That is an OG. Salty, you are amazing. You know how much I appreciate you. I'm missing Unsolved Crime. What's up, blah? Hi, Jen. ATS. Hey, Shaz. Hey, Mila's mom. Hi, Sleepy. This man is literally insane. That's Andy Goosey's in the house. A little Andy Goosey for you. What's up, Christy? Hi, Lorna. Greenie. Hey, Ramblin'. All right, let me go back down to the bottom, see if I missed anybody. Hi, Andrew. What's up, Stacy? Hey, hey, hey. What's up, what's up, what's up? Okay, so hi, Angie, baby. Hey, Cakey. Shelly, if my GoFundMe account is frozen, it should be fixed. There was some technical difficulties I know they were having over the weekend, and because it was the holiday weekend, they couldn't get it fixed. So I think that was one of the things they were working on today. Hi, J Rabbit. I'm a little confused. Did Gold deny Hennessy's response last week? Sorry, too much to understand. No, you're fine. So we'll go over it. So with the motion to I don't know why I keep saying the motion for contempt, she is taking it all under consideration. So what happened was she gave the defense the week to do a post-hearing memo, essentially almost like a closing argument, but just in memo form. And then a week after that, the state gets to respond. And now she has 30 days to make the decision on whether she wants to hold Rosie and Baldwin in contempt. So nothing is denied. It's literally just wait. Now she has 30 days from today to make a decision. She can make a decision today. Now that this is in, she just has up to 30 days to make that decision. Hi, Unsolved Crimes. Hi, Unindicted. Made it. Phew. Hi, Salty Beach. It's in the process of being corrected, and we will let y'all know once it's back up and running. Okay, perfect. There you go. Hi, Dina. We must stop meeting like this. Oh, Oksana, thank you for the super sticker. Thank you, thank you, thank you. That's much appreciated. And put that towards my my Indiana fund. I'm so nervous that it's like something's gonna change. I got info from GoFundMe saying they haven't received proper info, so no payment in and no payment out. So it's not GoFundMe, but I think I understand what you're saying just from the site. It's, yeah, that's why I said they were having the technical difficulties over the weekend, but I know they're working on getting it fixed. Hi, Lily B. What's up, BGOG? What's up, Teresa? Hey, Rebecca. Okay, so anybody that's just popped in, we are going to be going over Nick's response. It's considered the post-hearing memo is what she gave them the time to type up. So we're going to be going over that. I know anybody who was here last night, we went and did Todd Click's testimony. We did a read through. The participants were just amazing. And I'm waiting to hear back from Sleuthy. Let me see if she's messaged me back on when she wants to do the second part, where we can do Amber Holder's testimony and we can do Steve Mullen's testimony. So this just came out today, correct? Yes. So this is new. So I have that one set separate, just so this one's just to go over this for right now. Oh, oops. It's okay, no biggie. All right, so let me pull this up on screen for you guys. So this is just to talk about why Nick thinks that he is in the right and that the other two should be held in contempt. I do have an inquiry out so we were going through the motion to dismiss transcript. I do have an inquiry out on the motion for contempt transcript, but she seems to be on vacay, so I'm not sure if we're even gonna, how much we're gonna want it. Okay, Shelly, I'll take a look. Thank you. Hyperconsent. So, hey, Chelsea, the vendor issue is an issue with Stripe. It's being worked on and hopefully will resolve soon. Okay, if I live closer to Delphi, you totally could stay with me. Your own room and bathroom. What? Hi, Miranda. Is Sleuthy the same as Sleuthy Goosey? If I say Sleuthy, it's typically Sleuthy Goosey. Because there's so many. Because then I have another moderator who's Sleuths Investigate. And then, I mean, there's a lot of people that just then have lots of sleuthing going on. Sleuthy. Hi, Chris. All right, let me pull that up. Hi, Ariel. There ain't no way NM wrote this. It actually flows. Still reaching like usual, but not as bad as NM's usual legal writing. Maybe Stacy wrote it for him, or he has a new paralegal. Let me see. Let me just respond to this real quick. Okay. I have it on good authority that this is preposterous. Oh, Caitlin, you're not really that late. But only one goose. Hi, Marshall. I don't be checking my notifications. Like T doesn't really understand how special she is that I answer as much as I do. Oh, no, I do. I actually do know how special I am. I do. And because it was progressive. I mean, a year and a half ago, it would have been like 4 or 5 days later. I at least get one typically within 24 hours at this point. So I know where I'm at on that ladder now. Okay, so let's get started on this. Hi to everybody who has just popped in. I'm going to start reading through. So like I was saying, this is the state's memorandum in support of contemptuous conduct. Dun, dun, dun. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and files its findings of fact and conclusions of law for the hearing on the information of contemptuous conduct filed by the state. A hearing was held on the contemptuous information on March 18th of 2024, and evidence was heard and concluded. The court accepted the exhibits into evidence and took its decision under advisement pending memorandums filed by each side. The state now files this memorandum in support of the information for contemptuous conduct. Like I said, we went over Hennessy's memo last week, so if you missed that, go back and check that one out. Hi, Deets. So this is now number 2, the contemptuous conduct. I'm going to turn this off so you guys aren't just staring at the side of my face. The exhibits that the state put into evidence support the contemptuous conduct on the part of Brad Rosie and Andrew Baldwin, outlined in the state's information for contemptuous conduct. The deception to the court began in November of 2022. Like literally, they were assigned the case, and they were in contempt, according to Nick, or deceiving the court. I should say they weren't in contempt yet. But when both Brad Rosie and Andrew Baldwin told the court that a gag order was not necessary because they had no intentions to talk to the media about this case. Within a week, both Brad Rosie and Andrew Baldwin published a press release to media outlets. I just want to go back and clarify, and I don't know if I have it handy. I might. But Nick actually put out a statement to the media the day after this conversation that he's discussing. Just want to make sure that everybody's on the same page with that. Like, he literally put out a comment to the press release, or to the press release, and put out a comment to the press the day after this conversation that he's talking about. So I just find this so hypocritical. The order was not necessary because they had no intentions to talk to the media about this case. Within a week, both Brad Rosie and Andrew Baldwin published a press release to media outlets. Brad Rosie testified at the contempt proceedings that this was to curry favor with his client. It is clear that the press release was to curry favor with the public. Although it was not a violation of any gag order, it was a preview into future contempt shown to the court by by showing blatant dishonesty. So now we're going to go. You guys are getting real-time reaction. This is the first time I've read this. So now we're going to go into what it looks like to go from past, what you've done in the past being representative of what you're doing in the present. Does this not fall under the exact same category that he's fighting against when it comes to the exculpatory evidence that was deleted from 2017, or am I just making that up? I don't get it. I love real-time react. I haven't heard it yet either. Yeah, this is my first read. This is my first read of it. He's too much, geez. Kind of like the certified letter he withheld from the defense. I'm like, wait a minute. Like, so if your past behaviors represent what you're currently doing, I think that you're back at the same point. So if one is wrong, then both are wrong. The next act of indiscretion was an email from Andrew Baldwin to Brandon Woodhouse. This email was a violation of the gag order. No, it was not. We can read through the gag order and go through the legalities of that gag order. The email released information from discovery to a member of the public. That member of the public then further disseminated information protected by the gag order by putting it on the internet for the world to consume. While the content in that email may not be egregious to the court, the fact that Andrew Baldwin and Brad Rosie hid their error from the court until it was found by the state is egregious. Showing yet another example of the defense deceiving the court. Finally, the defense intentionally and knowingly leaked information to the public in the form of crime. Intentionally and knowingly leaked information to the public in the form of crime scene photos and other discovery protected by the gag order and the protective order. The state admitted screenshots of text messages between Mark Cohen and Robert Fortson, neither of which are involved in the case in any way, nor are they employees or team members of anyone involved in this case. While these screenshots are voluminous, they paint a clear picture. You guys all know how I feel about screenshots. This is okay. They did not, mind you, he did not bring, not even the actual, no, there's no actual download or anything. No download of anybody's phones, nothing. Just screenshots is literally all he had as evidence to present. Screenshots of the conversation between Mark Cohen and Robert Fortson. They paint a clear picture. Robert Fortson speaks about information that is only privy to the defense. Robert Fortson talks about it within days of the defense receiving discovery from the state. Robert Fortson has copies of the crime scene photos. He knows when defense is working on certain aspects of the case. And he knows about the oral interview with Professor Turco 3 days after the recorded statement is turned over to the defense. The defense states that Mitch Westerman broke into their office and stole the pictures. That is not what they stated. That is not what the defense stated. This is an absolute misrepresentation of what was stated. And then released them to Robert Fortson. It is clear from the messages between Mark Cohen and Robert Fortson that Robert Fortson received the crime scene photos and other discovery from Mitch Westerman. It is also clear that Mitch Westerman was feeding Robert Fortson several other pieces of discovery all the way up until October 2nd of 2023. I don't know, they're saying he broke into the office. He didn't break in. Now we'd be having a totally different set of charges against Mitch Westerman. See, this is what's frustrating to me. This is when I get mad, and I just like, how does this even make sense? Why do you have to, for anybody who tells me that they don't make up stuff to put in the documents, somebody right now tell me that that is not made up. And then tell me that this prosecutor doesn't make up stuff to put in the documents. Because we know something to be factually true, and this prosecutor is still putting it into a legal document. It's totally made up. Why? I mean, why not just tell the damn truth? This is when I go, people think like, oh, you're so pro-defense. No, this is when I'm like more anti-prosecutor, because this is bullshit. We all agree that Mitch Westerman broke the law and should be held accountable for leaking the crime scene photos. I think absolutely, Miranda. I think that he should be held accountable for doing what he did. I just don't know legally if he will be, because it's such a gray area. Even the charges they have on him with conversion, I think morally and ethically is very different than I think what they're going to be able to actually do with the elements of the law, elements of that crime of conversion. So yes, I want him to be held accountable. I just don't know if it's going to be legally or if it's just going to be, I mean, you know, his wife left him because Rosie called out the fact that he was in town visiting his girlfriend. I mean, maybe. Show the screenshot, prove that. Which part, Fishfinder? You tell me. Hey, Coolest Reviews. What's up, CJ? Isn't it crazy that we put the trial off for this, and this is the best you get from Nick? Right? Well, I mean, does that not just feed more into what people like to call a conspiracy theory on the fact that the trial was pushed out for this, to make this up? We know that's not true. So, and then I know I'm going to get the comments, well, the defense does the same thing. Well, everybody's super pissed off at the defense. So I don't understand why it's like everything that they do on this side is so okay. It's okay to do that. It's okay to lie. It's okay to make stuff up. It's okay to exaggerate the truth. But if the other side is doing it, it's like they're sleazy slimeball defense attorneys doing what slimy sleazeball defense attorneys just do. And my point is, this is just what the attorneys do. So why we just say, oh, I have blind faith in Nick McClelland, or I have blind faith in Andrew Baldwin. That's their couple name. That's Rosie and Baldwin together, by the way. Like, don't. Like, this is proof. There was no break-in. He was not charged with breaking and entering. He was not charged with breaking in. Why exaggerate it? We already know the truth. Just put it up. Yeah, Baldwin. That's Baldwin. Oh, hi, Judy. Hi, Mal. Sorry, I wasn't looking at chat, so I probably missed a ton of you guys coming in. Oh, they could be bald wheat. Bald wheat. This is what frustrates me. And it's like, why can't you just have faith in the fact that they're doing the right thing? This is why I don't have faith. If you're going to make up bullshit about something that ultimately is not even relevant to the trial and not even relevant to getting justice for the girls, I struggle. All eyes on Delphi. It was a breach, not a leak. Well, he leaked it after. He did. He leaked it to Fortson, and then it just went from one to the other to the other to the other, and that's just how it all went out. But what he did, the screenshot that proved no break-in. Sorry, maybe I misunderstood. That proved no break-in. Well, they testified that it wasn't a break-in. I can also pull up Nick McClelland's other motions where he states that Mitch Westerman was in the office and essentially just copy and paste what Baldwin said, which was that he was in the office waiting to go have lunch with him or something along those lines, and Baldwin was in his office. And so here's Mitch just wandering around and then goes in and takes photos of the photos on the table. Yeah, it's not a break-in. There was nothing locked. There's nothing, there's nothing stolen. We can look up the elements of what breaking and entering actually is. Yeah, his war room was breached. Yeah, committed a walk-in and stole. And I'm not excusing what Mitch did, and I don't want anybody to think I am, because we wouldn't even be in this disaster if Mitch was a stand-up fella. So I'm with you on that. Okay. The leak was recurring. It is also clear from the text messages between Mark Cohen and Robert Fortson that the strategy to leaking the information is to gauge the public opinion of the leaked information. Okay? Absolutely irrelevant. Because you've already stated up here, where is it? Neither of which are involved in this case in any way, nor are they employees or team members of anyone involved in this case. So their conversation between each other, as shitty as we think it is, still isn't, they're not doing it. They're not members of anybody involved in this case. They have nothing to do with that. Thank you, where's Shelly for the super sticker. Hi, MK. Where at Miranda there, they used text between Fortson and Mark, nothing from Westerman to Fortson. Right. And that was the other thing. And why I think that, and why I want the contempt transcript is because from my understanding, from all the notes that we compiled and Sleuthie wrote all out, nothing in there ever showed that Westerman was actually the person talking to Baldwin. Because what they have is the communications between Fortson and Cohen. And in those, Fortson just refers to, like, my guy. He doesn't say, hey, my buddy Mitch, or, hey, my my lifelong friend Westerman, who used to work with the defense attorneys, is telling me. He doesn't name him. He just says, like, my guy. which is when Holman contacted Mark, he was really looking for information on Westerman. But Mark was like, I don't know who that is. Like, I don't know who that is, because that's not, he never was referred to by name. So whatever they're deciding to do with this information has nothing to do with the defense team. Yeah, that's like me. Yeah, if me and Sleuthy Goosey are talking, Miranda is not a troll. No, she's not. She may have a difference of opinion on Richard Allen, but she is absolutely welcome here. So just everybody make sure you guys are respecting each other's opinions, as always. We've been doing really good with that lately, so let's just stay on it. Let's see. Oh, here. You Rick Allen fluffers. Oh my gosh, this is hilarious. Yeah. You know what? If that's what you consider speaking the truth, then I guess that's what it is. Go enjoy your day. Got a little worked up. You did not disappoint. Well, I'm so happy that I've made your day. Go enjoy the rest of your Monday on Silent Bob. Smoke another joint. Fluffers. Fucking idiots. That's how you know somebody has never actually listened to what I have to say on this channel, and they just come in thinking like, ooh, I'm going to go in there and I'm going to troll because I think it's really cool to call people names and say stupid shit when I don't even know what I'm talking about. Gotta love people like that. So anyway, okay. So where were we at? So it's also clear that Mitch Westerman was tweeting. It's also clear the text message between Mark Cohen and Robert Fortson that the strategy of leaking the information is to gauge the public opinion of the leaked info. Well, yeah, that's their strategy. That's between Mark Cohen and Robert Fortson. But like we said above, they don't work with anybody. They don't work with Nick. They don't work with Andrew Baldwin. They don't work with anybody involved in the case, according to Nick McClelland. It was an effort by the defense to put the information out to the public to gauge the response of the defense's theory of the case. Where in any of that does it say that the defense did that? He literally says they are not employees. Neither of which are involved in the case in any way, nor are they employees or team members of anyone involved in the case. It's right there. But now all of a sudden it's like, nope, they're working for the defense. They're working for the defense. It was an effort by the defense to put the information out to the public to gauge the response of the defense's theory of the case. Bullshit. I get that people believe that. And I also get that there's people who think that Mitch Westerman was working for Nick McClelland. I'm going to tell you right now, there's no proof of any of that. There's no proof that Mitch Westerman was purposely doing anything on behalf of anybody except for Mitch Westerman himself. If there is proof of it, I do not understand why it would not have been presented at this hearing. Yeah, now they are a teammate, but they don't actually work with them. It was an effort by the defense to put the information out to the public to gauge the response to the defense's theory of the case. This would allow the defense to change that strategy if the public response wasn't one that they thought was beneficial. That's an interesting theory since these people aren't connected to the defense. The screenshots from the iCloud account of Mitch Westerman. The screenshots are of text messages between Mitch Westerman and Andy. Again, the messages are voluminous, but if the court will read through them, the court will clearly see that Andy is Andrew Baldwin. In the text, Andy talks about writing the Franks memo and how it is a huge endeavor on his part. In other messages, Andy encourages Mitch Westerman to reach out to the media and push their narrative. Okay, why, and maybe this came out. This is why we do need the transcript. Not one person, either pro-prosecution, pro-defense, pro-anything, ever said that was said in that hearing that day. Anybody that's in this chat right now that was in the hearing that day, somebody tell me that this was actually said. because nobody, and I tried to listen to everybody I possibly could that was at that hearing to get their interpretations of what they heard. So I wasn't even just doing one-sided like kind of thing. I listened to everybody. The Odinist garbage is basically racially charged. It makes the defense look so desperate that they have to find a race card. I don't think they're going for a race card though. So I think what you're not really getting on that part is what the people that they believe were involved in the crime are practicing Odinists. I think that's the difference. That's my opinion, Anna. You can have yours, but that's mine. We have the motion to dismiss transcripts. We don't have the contempt transcripts. Yeah, I mean, they are white supremacists. So, I mean, I don't know if it's a race card, but like I said, that's my opinion. You are absolutely welcome to yours. And let's go back to understanding that we're talking about three separate pieces of this case, and I've done my damnedest to try to separate them into, we have the information regarding the leak, we have the information that we had regarding like the Supreme Court hearing and this contempt stuff, and then there is the case against Richard Allen. Because somebody's opinions about this piece of the case are one way doesn't mean I'm all for freeing Richard Allen. They're not the same thing to me. And I get that to some people, this is all inclusive. I can only explain how I am trying to break it down. It's very different for me. What is happening here is it has nothing to do with whether Richard Allen is innocent or guilty. I mean, he is innocent until proven guilty. Don't get me wrong. We can go back to that. But what I mean is having an opinion about this doesn't change whether the evidence will make sure that Richard Allen goes away or he'll be exonerated. That's not the same thing. So this is crazy. Are they? Okay. Well, we're not going to be super long, so you should be okay. So I just want anybody who was at the hearing, somebody, please tell me whether this statement right here was actually brought up in court. In other messages, Andy encourages Mitch Westerman to reach out to the media and push their narrative. Andy further states that he has already been in touch with Dateline and spoke to them. All of this is a violation of the gag order by Andrew Baldwin and the defense. I just want to know if this is even true. This did not come up on anybody's information. Yes, I agree with Charlotte. So I'm like, I don't care if people think Richard Allen is innocent or guilty. I'm not here to fight the battle of his innocence. That's not what we're doing. So they're welcome here whether they think he's absolutely the right guy, and they're welcome here if they think he's absolutely the wrong guy. You're just not welcome if you're just mean to each other. I just want to know if this is true. Okay, Kathy, you were in court. You did not hear that in court. I don't know. Well, what I do know is that he should not have any idea what the conversation was between Mitch Westerman and Andrew Baldwin when it came to the case. Mitch Westerman is not his case. But that's another story, and that's up to the defense whether they try to have the court hold them in contempt, or have them hold Nick McClelland in contempt. But my problem here is if this is true or not. Yeah, the right guy people have now made very good points. That's also, I mean, like I said, I really try to, just be nice to each other. You can just be nice to each other. Hi, Nance. Hi, Jeanette. I can't say RA is 100% innocent, but I feel he is probably 65 to 75% innocent. That's an issue. I don't feel good. I don't feel like a conclusion to say that. But what I do feel is like something is This just doesn't make sense. Why do you have to make shit up? Nancy, you were in court. Here, tell me if you heard this, because this isn't in your notes either. And Kathy said she didn't hear it, and she was in court. It says, the messages are voluminous, but the court here. Here, it was clearly that is Andrew Baldwin. Okay, in the text between Andrew Baldwin and Mitch Westerman, they're talking about the Franks memo and how it's a huge endeavor on his part. Okay, here, other messages. Andy encourages Mitch Westerman to reach out to the media and push their narrative. And he further states that he has already been in touch with Dateline and spoke to them. All of this is a violation of the gag order by Andrew Baldwin and the defense. Do you remember that coming up at all when you were there? Kathy said she didn't hear it, but I'm now very curious to see who actually heard this and who didn't. Another thing is saying, hey, I spoke with Dateline is not a violation of the gag order. If Dateline calls him or emails him and he's like, hey, get in touch with me when the trial's over, that's still saying I talked to him. We don't know what the hell was said. Does he have any of the communications between him and Dateline? Because it would still be like this. I responded to him. So yeah, Dateline's already reached out and I responded. I just want to know if that's true. I want to know if this is true. Encourages Mitch Westerman to reach out to the media and push their narrative. Okay, so that's two. If anybody else was in there and anybody else that was at trial, let me know. Is it too small, Carol? Okay, hold on. I can go up. I can go more. I can go more. Sorry. I normally try to make it really big. Okay, Scott, no worries. Do what you got to do. Okay. Yeah, I don't know. This is interesting to me. We'll see. We'll see. When the state was notified of the leaked crime scene photos in early October 2023, the defense was on a phone conference with the court and gave the court the explanation that Mitch Westerman broke in and stole the photos. When interviewed by Indiana State Police, Andrew Baldwin stated that he gave the Franks memo to Mitch Westerman to review. Okay. Then at the hearing on March 18th, the defense implied that Mitch Westerman is now a consultant of the defense, and any communication between Mitch Westerman and Andrew Baldwin should be considered work product. The defense has consistently altered Mitch Westerman's involvement in this case. Why didn't the defense make the court and the state aware on October 10th, 2023 phone call that Mitch Westerman was a consultant and that he had access to discovery? Well, nobody said that he did have access to discovery. He had access to a Franks memo as a consultant, which I think it's in the affidavit of Baldwin. I'll have to go look. In the affidavit of Andrew Baldwin, he does state that. He states that he gave him the Franks memo. Well, maybe I guess he's already saying that here. Okay, Nick's got that. When interviewed by Indiana State Police, Andrew Baldwin stated that he gave the Franks memo to Mitch to review. Yeah. Doesn't state that he gave him discovery. It is the state's belief that the defense was trying to conceal or diminish Mitch Westerman's role in the leak. So that's just a belief. You have to be able to prove it. Could be right, could be wrong, but you got to be able to prove it. A reasonable person can deduce that the defense was trying to hide the fact that the defense was in, I feel very gaslit right here, Nick, was trying to hide the fact that the defense was intentionally leaking information. Once the state was notified of the leak and an investigation began where the state began to gather evidence, as the state got closer to the source of the leak, the defense changed their story from Mitch Westerman being a criminal who broke into their office and stole discovery to Mitch Westerman being, that's not how it went. That is not how it went. Assisting on the Delphi case, whose communication with defense is protected work product. The defense intentionally violated the court's orders and leaked discovery information in an effort to push their narrative out. This was a strategic move by the defense in violation of the court orders. Well, I mean, because if I don't believe what Nick is saying, it makes me unreasonable. You see how that worked right there? So, like, you have to believe me, otherwise you're unreasonable. Oh, such a good way to spend your afternoon, watching somebody that you don't like. It's so nice. I wish I had that much extra time in my life. Yeah. So, what am I reading, Nance? This is Nick's post-hearing memo from the post-hearing memo from the 18th hearing. Let's do this. I'm going to make you work for it. You want it, you're going to have to work for it. See you in 20. I'm just listening to how misconstrue everything you what? It's just listening to how misconstrue everything. You must be high, because that sentence makes no sense. You might want to slow down. I know I said smoke another joint, but I'm thinking you may need to calm down just a little bit. Just a little bit. Alrighty, here we go. This is a strategic move by the defense in violation of the court's orders. The crime scene pictures specifically continue to cause havoc across the internet and re-victimize the families of those involved. As recently as March 28th, 2024, oh shit, a YouTuber posted the leaked crime scene pictures on his channel to the public and ultimately to the world. That YouTube video made it back to the family, re-traumatizing them. It has become known that the YouTuber forwarded the pictures on to other YouTubers, and they continue to be posted on the World Wide Web. Despite the state and investigators spending countless hours trying to track down all the various outlets the pictures and discovery were leaked to, the damage done by the leaked crime scene photos seems to be ongoing. Okay. Despite the state and investigators spending countless hours trying to track down all the various outlets, bullshit. Bullshit. No. The damage done by the leaked crime scene photos seems to be ongoing. Here, Nick, you and me, same page. I do agree with that. FYI, this channel that did this apparently has been taken down today. Idaho Charlie, this is a new document from today, yes. So this is just a refresher for anybody who is just coming in. This is the prosecution's post-hearing memo from the contempt hearing that was held on the 18th. Judge Gull gave the defense 1 week to submit theirs, which Hennessy did, and we reviewed last week. And then Nick McClellan had 1 week after that to submit his, which falls on today, and here is his. And now Judge Gull has 30 days to decide whether she's going to hold Baldwin and Rosie in contempt. It was the photos with a filter, I believe. I don't know. There you go. A corrupt prosecutor that lies and misconstrues in a hearing. No, that's me, Stephen Curry. Don't you get it? Like, I'm the one that's just out here on YouTube misconstruing everything, instead of just saying, hey, these are blatant pieces of bullshit that are put into this memo and are proven false. You know, but I guess you could misconstrue that into it's bull crap, maybe, instead of bullshit. I don't know. But it's wrong. And it's not accurate information. And it's now in a legal document that is given to the judge in order to hold attorneys in contempt. So if they really did something wrong, just write in here what they did wrong instead of trying to exaggerate it, inflate it, or make it something that you didn't even bother to prove in a court of law. You're just putting it in here. So, you know, it is what it is. I'm sure there's going to be probably 3 to 4 channels at least that will go live tonight and go over these documents and tell you how wonderful Nick is and fluff enough of Nick for everybody. So if you guys are looking for that, have at it. There's going to be plenty of channels that you can go to. I'm not going to sit here and say that this is factual because Nick put it on a piece of paper. Ain't going to happen. Sorry, wrong one. Except for I do agree with him here. I absolutely agree. The damage done by the leaked crime scene photos seems to be ongoing. Absolutely, it is ongoing. I absolutely believe that the families are being re-traumatized over and over by social media that continue to show it. I absolutely agree with that. So Nick and I, same page. Same page. The no fluff. Yeah, you can get some fluffy Nick fluff if you want. You want to get some Nick fluff, you go somewhere else. Hi, Veronica. Hi, Kathy. All right. Governing law. Contempt is an inherent power of the court. The contempt power is not bestowed on the courts by statute. Among the inherent powers of a court is that of maintaining its dignity, securing obedience to its process and rules, rebuking interference with the conduct of business, and punishing unseemly behavior. The statutory definition of contempt is just legislative recognition of the court's existing authority. The same inherent authority can support sanctions without contempt. Courts can exercise their inherent authority to enforce their orders and protect their dignity through sanctions that are not explicitly tied to a contempt finding. Courts have upheld the imposition of sanctions in a number of contexts not explicitly involving contempt. A commonality is that these circumstances arose within an ongoing judicial process and the sanctioned persons were engaged in that process. Contempt is a unique proceeding. It's not civil or criminal. Contempt, however, is not a criminal offense. It is a sui generis proceeding, neither civil nor criminal in nature, although both of those labels are used to describe certain categories of contempt. Yeah, like the Indiana law. But criminal contempt is not always readily distinguishable from civil contempt. But a particular contempt proceeding is described as civil or criminal in nature based primarily on the purpose of the sanction. True. Civil contempt is the label applied to sanctions meant primarily for the benefit of the party who has been injured or damaged by the failure of another to conform to a court order issued by the private benefit of the aggrieved party. All right, we've gone over a lot of what this contempt stuff is. Let me see if I can pull that up for you guys, because I kind of did like a contempt for dummies slide. Now, where did I put it is another question. Nope, that's the leak. There it is. Hold, please. Put this back up. I love the contempt for dummy slide. So this was actually, I made this for me because I was the dummy and I was like, okay, I need to actually be able to see this. Send it to Nick. So, goodness. Well, he's citing a couple different things. He's saying like, hey, there is no difference between the two, that the judge has or the court has the ability to kind of just do what it wants. And then it's like, well, maybe not, because then these other ones say like this is criminal and this also says that this is civil. So I did make this. Anybody wants to screenshot it and take a look at it later. I've also posted it in some different places online, different discords and whatnot. But it talks about what different kinds of contempt. So there's civil contempt, and then under civil contempt, there's indirect and direct. And it just takes you through the steps of what you actually can and can't do based on each side. So he's saying like, it's kind of like it can go either way. And it's like, no. And this is what Hennessy kept trying to reiterate was like, hey, you guys need to tell us what the hell we're even doing. Osbrook just posted on Twitter that there are more important things happening. Let me go see what he wrote. What does that mean? Is there any... I don't need another Riddler in my life, Osbrook. We already have one. Now, let me go see what he wrote. Oh, shoot, I muted myself. Sorry, I was talking over here. I'm just like, yeah, you do this, whatever. Right, and Osbrook said before it was criminal, Goal couldn't even preside. Right, T, you could design and develop board games for attorneys. I'd be like, okay, Nick, you're here. You have to either go here or here. And he's all, no, I'm going to go in here somewhere. This is where I'm going to sit. I'm just going to play over here. And it's like, no, that's not part of the game. That's not part of the board game. We don't look alike, though. We just kind of sound alike. So it's probably when my camera's off. Does anyone know if Kara has posted on Twitter about this? I don't know. We're going to check out. We'll check out Osbrook first. Okay, so here's what's he saying. Just read. Okay, hold on. Let's go down a little bit. See what he says first, so we can get some context. This is the first time I needed a flow chart to follow a channel. Okay, hold on. While waiting for McClelland's contempt argument today in Delphi, I have some other things to write. Coffee and the SI have gotten me in the mood. Thy tongue outvenoms all the worms of Nile. Now for a machine gun banjo music to type by. It's all fun and games until the banjos come out. Oh, man. Okay, so then he puts 22 minutes ago, just read McClelland's latest contempt thingy. Just waiting for orders. Oh. There are more important things happening. Yeah, like the case against Richard Allen. But he's waiting for orders to see what they're going to do. To see what they're going to do. I got nothing. I got nothing on that. Interesting, interesting, interesting. Okay, let's take this down too. I'm telling you, I keep saying the stuff that Nick is putting in these filings, that he's over here just reading whatever the hell he wants to read when it doesn't even have anything to do with his case. He's not the prosecutor on Mitch Westerman's case. So how did he get access to that information? It's not discoverable to him. It's not, he has nothing to do with the investigation. That's a problem. And this is what Hennessy was trying to point out to Goal and to, or regarding Goal and regarding McClelland. Like, you guys are trying to investigate this yourselves, and then you're trying to preside over the hearing, and you're trying to be the person who's prosecuting it. Like, you can't be involved as an investigator and be the people here in court. You can't do both. So I don't know. They just keep doing whatever the hell they want to do. No way. Who's your divorce attorney? I was rooting for Nick and thought RA was guilty. Now I'm disappointed in Nick and have reasonable doubt about RA's guilt. Geeked, is it not weird that it's almost like the things that he does and the things he puts out, or the lack thereof, and the weird exaggerations on other things is what makes you go, well, if you're doing all of this, maybe you are doing all of that. You know what I mean? Like, kind of like he says up at the beginning, he's like, this is just a precursor to all the bad things that they're going to do. I feel so bad for the victims in the community that Nicky Boy is responsible for getting justice for Abby and Libby. He's a fucking disgrace, an embarrassment. It's so sad it's gonna get his ass handed to him. And this is one thing that I don't think people really wrap their minds around, is if Richard Allen is the right guy and Nick's shenanigans is what gets him off. Now what quote unquote side are you going to be on? Like, I don't think people think about that. It's like, oh no, they have the right guy, so Nick is untouchable. And it's like, no, Nick keeps fucking around, and Richard Allen, if he is the right guy, isn't going to be convicted. Okay, so anyway, so back to what he's saying. And so this is that's why I wanted to show you guys the little thing on the contempt, because I think this makes more sense if you can actually look at it and see the differences. So criminal contempt sanctions are considered punitive because their purpose is to vindicate the authority of the court, and it benefits the state rather than the aggrieved party. So like, if you aren't paying child support and you're supposed to, then you could go to jail, and the court ordered you to pay child support, so you would go to jail under a contempt of court order, but it would be in order to get you to pay the child support. Does that make sense? So it's different than in the criminal contempt. It's that you didn't follow the court's order, and you actually, your victim is almost the court versus another person. So contempt is either direct or indirect, and is the chapter addressing direct contempt, is the chapter addressing indirect contempt. Okay, direct contempt is based on conduct that happens in or near the court itself. There is no written charge or complaint that is required. The court simply states the offending conduct and later reduces it to writing. The court may immediately enter judgment and punishment. And I'm not reading you all the codes, so are we going to get the transcript of it? She's not back until the 8th, and so I'm hoping to. I guess it really depends on, come the 8th, do we want it still? Is it important to still go through? Does she already, does Gull already make her decision? So I'm kind of weighing the timeline to see if it's important come the time that she said it'll be available if I want it. Give me 1 second, you guys. Okay, so indirect contempt occurs outside the presence of the court. The statutes identify. So contempt, this contempt that we're talking about right here, like direct contempt, is typically what you see like in movies or TV shows where like the attorneys are just, going off, and the judge is like, you're in contempt, and then, you're out of order, and then this whole court is out of order. But that's what that is. So like direct contempt, it's happening right in front of the judge, and she's going to be like, nope, you lock him up, guys. Like, throw away the key. We're done. We're not going to deal with that crap. That's direct because it's happening right in front of the judge, and that person is not listening to what the judge says, because it is ultimately the judge is the court. That's it. It's her rule. So down here, it's indirect contempt occurs outside the presence of the court. The statutes identify 4 distinct bases for indirect contempt, which is disobeying the process or a court order. Everything he's citing here is where I pulled all of this information from. So this actually kind of just aligns with it. It's like contemptuous action not in front of the judge. Was it willful or deliberate? If it's no, then nothing happens. If it's a yes, then the state must show cause. It requires a special judge and requires a new action. So what he's actually citing is literally what I used to make this. So intimidating a witness is outlined, or false reporting about a case or proceeding is outlined. Besides, the conduct happens outside the presence of the court. Someone has to inform the court of the conduct. Hi, rescue. You guys do know that this third-party culprit defense essentially shifts the burden onto the defense where they didn't have one before. Why would they choose this if not confident? Absolutely. I don't know why they're confident, but I know they seem to be. How are screenshots not hearsay? So they used an exception to hearsay on that, which is just a whole nother. I don't understand how they ended up doing that, but then anything that the witnesses that came in for the defense, they were told that it was hearsay and weren't allowed to do that because those people weren't there to testify. Now, the irony is Nick could have had Mark Cohen there to testify. So let's see. Was Snee an example of being held in contempt of court? No, he was just banned because he just didn't follow the court's decorum as she believed it to be, and so she just banned him from coming back. Oh, Jennifer, thank you for my travel fund. Woo woo. But they weren't from a phone dump. They were fucking screenshots. I know. And they weren't even Here's the thing. They weren't even screenshots that Holman had gotten directly from Cohen, and obviously not from Fortson. They were screenshots that Cohen had given to Murder Sheet, and Murder Sheet gave to Holman. Veronica. I BJBC. Okay. The conduct happens outside the court. Someone has to inform the court of the conduct. So this is what he's saying. Like, this is the indirect criminal contempt that he's talking about. Like, he's the one that's informing the court of this conduct at this point. Then notice is given to the accused with a chance to confront and answer the allegations. In our case, the court is considering indirect contempt, where the defense was given notice and a chance to be heard on the information. In Indiana, contempt is completely unique proceeding. It comes from the court's inherent power to enforce its authority and protect itself from interference. The words civil and criminal are just descriptions of types of contempt based primarily on the purpose of the sanction. Civil contempt sanctions are meant to benefit the other party, and criminal contempt sanctions vindicate the authority over the court itself. That's literally the difference. So you do know the difference. They're just descriptions of types. Yes, very good. The same contemptuous conduct can give rise to sanctions of both types. Prosecutors, like any party or any reasonable person with reason to believe someone should be held in contempt, can file a verified information with the court providing the reasons. Whether the alleged contempt must be addressed in a separate case by a different judge depends on the type of contempt alleged. The defendant's alleged conduct and not the purpose of the sanction. This is not a response to his memo at all, in my opinion. Yeah, the statute lays out this procedure. The statute says no special judge is required if the alleged conduct is disobeying a court order, which is the conduct alleged here. No, it's not. It's not even what you're alleging. You're alleging that they knew a court order could be coming and they said, what are we on, page 5? And let's go back up so I can go over exactly what he said. In November of 2022, Rosie and Baldwin told the court that a gag order was not necessary because they had no intentions to talk to the media about the case. Okay, so there is nothing. So you just don't like them because they said that and then they put something out? You see what I mean? That is not a violation of anything. It's like, but you said you were going to share my screenshots and then you went and shared all my screenshots. So I'm going to hold you in contempt. No, it doesn't work that way. There was no legal anything about it. Okay. The word civil and criminal descriptions. I already read that. Okay, let's see. Prosecutors, like any party or any reasonable person, responsible. Did I say reasonable? I don't know if I said that when I read it, but it's responsible if I did. This must be addressed in a separate case by a different judge. Depends on the type of contempt alleged. The defendant's alleged conduct and not the purpose of the sanction. We already read that. Which is the conduct alleged here. No special judge is required in indirect contempt growing out of willfully resisting, hindering, delaying, or disobeying any lawful process or order of court. The allegations here by the state are that Andrew Baldwin and Brad Rosie willfully disobeyed a lawful order of the court after they were served with it. After they were served with it. I mean, right there, that's knocks out number one. It's just done. You can hear my mouse clicking. Can you really? Dang, my mic picks up a lot then. Well, Nick said he gave over all the discovery already, but we know that ain't true. Well, he's all, I gave you all the discovery, except for the stuff that obviously was deleted and we forgot to tell you about, because we didn't tell you about that till later. A lot of the fuckery comes from the state thinking the case would silently be charged and done. I agree with you. I do agree with you. And I think that's why I say, like, a lot of what I think that they have done is to cover up their own shenanigans or the own things that they make a mistake on. Arthur Peck, did Frank give a reason for showing the photos? The only thing that I know was that it was about Joe Louis or something along those lines, showing them, and then he was like, you guys are, I think it's, I can't actually tell you. I can only surmise. I can't actually tell you. Okay, so to constitute indirect criminal contempt, the act must be done with the intent to show disrespect or defiance. Okay, here we go. The act must be done with the intent to show disrespect or defiance. This word right here, intent, is the biggest part of what I don't think Nick was able to prove. Now, obviously, I'm not Judge Goal. I'm not the one who gets to decide. So my opinion is just my opinion that I share here on my channel. Shoot. If this was an issue, this should have been presented by Nick in the contempt hearing. Sounds like his YouTuber trolls dug up some more dirt for him. They will end up screwing the case up for him. I would not be surprised. Joe didn't show actual photos. He showed the sticks on her side. Well, it was the photo. It just wasn't the face. But yeah. It always starts with hiding incompetence. Then it balloons into a conspiracy because you were too stupid to admit you screwed up in the first place. Right. And then you just gaslight us by telling us if we don't just believe you, then you're unreasonable. If we don't just buy into whatever you're selling, we're just unreasonable people. And that reminds me of some of the people on YouTube. And I'll tell you right now, you don't have to buy anything here. You can walk away about feeling any which way you want to feel about it and go on with your life, and I'll see you all tomorrow again. Like, I'm totally okay with it. Frank's did, Shiraz. Little Frank. Frank has a new. Oh, really? Ooh, I did not know that. Nick takes this to court under Gull. Gull ignores the question of intent, finds them guilty. They're kicked off of RA's case mid-flow. The only thing, Luke, is that once again, she's the judge. She'll do what the judge wants to do. But the punishment is supposed to fit the crime. And the punishment for contempt is either a fine or jail time. Now, I kept going back to even before the contempt hearing. I was like, is she going to try to finagle some other? Because obviously there's like loopholes in law all over the place. And then you have to know every state's loopholes and every state's laws. And that's really hard to do. So does she have some other loophole after the fact to be able to remove them because she found them in contempt? But the punishment for contempt is either the fine or jail time. I don't know. They can appeal the application of law, but it won't be about whether she was the right judge, and it'll also be too late because they'll be gone. I'm assuming that is. The other thought that I have on that is this is, we just looked at Osbrook's Twitter, and I didn't check Kara's. I should have, but I didn't. And they're waiting to figure out what's going to happen here. I know they are. You can sense it. They're still paying attention to everything that's happening on which is going to be the legal recourse that they have based upon what's happening right now. And I think, as many people are like, Hennessy, he was too old, he was too this, he was too that, he's too arrogant, he's that, whatever. The one thing he is intelligent. The guy knows the law. He's been doing this for a very long time. And he's obviously very good at it. Even if he's not in his prime now, that doesn't take away the years that he has put into understanding this law. And he's like, this isn't important. This isn't what you guys should be focusing on. So depending on what happens here, I don't know if we're going to be back at the Supreme Court, if what Osbrook's going to be doing or what Kara's going to be doing. I don't know. I just feel like hopefully she just says, here's your fine, pay your fine, and go on. Or she actually sees that none of these things matter. Because this is the next part right here when it talks about to constitute indirect criminal contempt, the act must be done with the intent to show disrespect or defiance. So when we go back to number 2 of what they're talking, or what he's claiming, is the email to Brandon Woodhouse. On the stand, they talk about that the email was actually addressed in the body of the email. It was addressed to Brad. So you can tell there was no intent, that it was accidentally sent to the wrong person. Now, can we say that Baldwin is obviously has some negligency? I don't know if that's the right word, but did he have some negligent things that were happening around him? I would say absolutely. This is why I consistently say, like, the one that I feel like is not in this pile of shit is really just Rosie. Because do I think that Baldwin did it intentionally? And nobody has shown me proof of that to make me believe that. I know that's the theory. I know that people out there suggest it. I know that people out there suggest that, that Nick had something to do with the photos coming out. I get it. The timing on all of it is very suspicious. But once again, we don't have proof of that. And until we do, I think we can't just go around saying, hey, we can say that maybe we think that, but to say it's factual, it's just not. We don't have that as a fact. My chat's like not scrolling. This is weird. He's to face the defense in court. Hey, digital. Hennessy lead pipe versus Nick. What about the sketches? I don't see any reference to those by either side. See, that's what's also very interesting to me too, was because I thought they were I thought that they were really going to focus more on that. Like when we were reading through some of the other documents, obviously, ironically, they said that they kept saying crime scene photos and documents. And I was like, okay, well, it can't be the Frank's memo, like itself, because that's not necessarily the document that would be a leak from discovery, because that's not part of discovery. So then I was like, maybe the crime scene photos or something along those lines. Not the crime scene photos. I don't know why I said that. Maybe it was the sketches, because remember the other two sketches also got leaked. At this point, Click and RA need more protection. Gull trying to possibly put away wrong guy and overlook those other guys whom they lost interviews. I will say this is my, on behalf of Judge Gull, she is taking the motion to dismiss under consideration, versus she could have just denied it that very day. She could have just said, okay, thanks, you guys, thanks, Baldwin, you just wasted my time, and this is denied. And she didn't do that. So maybe she's paying more attention. And like I said, anybody that was in the courtroom did say that she seemed to be the most alert and actually like paying attention to what was happening when the motion to dismiss was there and like Click was on the stand. So maybe, I don't know. But then you also have to think, just because it seems one way or we can see it, she still has to go by what the law is. She has to. Well, she's supposed to. And that might be true, but hey, you know what? That's better than the Franks where she's like, hey, I didn't even read it. And then she's like, I'll give you new attorneys a hearing. And then the other attorneys come back and she's like, nope, sorry, denied, no hearing. Hopefully she's taking, we'll never know. We won't actually know. So we can either give her the benefit of the doubt on it or not. I get it. But at least she could have just said no. He thought better. I did. I chuckled at myself. Got ×2. Hold on. What's Sweet Dude say? Let me find Sweet Dude up here. Sweet Dude Shibby. The snake said both or changed what he said. Hold on. Okay, you responded to Diamond. Okay, so Rick Snay had a rectangle and a circle. That's what he received. When all of this was happening, he's like, I swear I had a rectangle and a square. Like the following day, he made a community post to correct that and said, I was wrong. I did have a rectangle and a circle. So what happened here, this isn't two sets of photos. This is, that set of photos was given to people and somebody changed the shapes on the photos so that the person they gave it to, who said, I won't share it with anybody, the person would know if that person shared it with anybody, because the shapes were intentional on what that person decided to put on there. I know that people don't want to really understand. I cannot prove it to you, but I have the proof. And you guys know how I feel about proving stuff to you, because I would totally do it, but I will not do it in this circumstance because of the nature of what I'd have to prove. I cannot do it. I just can't. So it was a rectangle and a circle on all the photos. It went to one person who was going to send it to a friend of theirs, and that friend wasn't supposed to share it, and that person changed it to a rectangle and a square. So I just want to, and then that person did share it, and then obviously that went around also. So now there's two sets of the same photos. Right, he didn't, yeah, he had the square. Hence the person who, this is why I said the leak was not this mass email leak. That was like this narrative that was being pushed at the very beginning of this leak. It was just like, it was weird. And I was like, I'm going to get to the bottom if there's really a mass email. Like, there's just not. That No, KO. No. But there was it was literally from one person to their friend, from that person to their friend, and maybe that person to two friends, and then those people to two friends, and it just, yeah, it's just added, like it just went out that way. So there was no mass email. Yeah, social media, that's for sure. Um, let me see. Oh, yeah, I don't even I don't even know what to say about that. Honestly, about that video. I don't know what, I wish I knew what the answer was, but I don't know if I'd ever understand it. But I don't think that was the same. I don't think that was the same one, KO. That probably was putting on his live to BO before he did it. To BP, you mean? To Becky Patty? But then Nick blames the defense when Holman said he stopped trying to see who had them. Right. Well, that was the other big thing in here was like, we spent hours and hours trying to figure out everybody who had them. And it's like, no, nope. We wouldn't be here if you had actually done that. And you didn't confiscate anybody's phones to make sure that they actually deleted them. You just talked to them on the phone and said, okay, delete those photos. And that was it. But here's the thing. The point of this is the intent. And so when I was talking about intent, it has to do with the fact that Baldwin did not intend to send the email to Woodhouse. And I think that was easily proven when it actually said, hey, Brad, in the body of the email. But, it is what it is. Intent is a factual issue to be decided by the court after hearing all the evidence. Okay. Our Supreme Court has held that the respondent has the burden of establishing that her failure to obey the order was not willful. The determination of whether to find a party in contempt permits the trial court to consider matters which may not, in fact, cannot be reflected in the written record. The trial court possesses unique knowledge of the parties before it, and it is in the best position to determine how to maintain its authority, justice, and dignity, and whether a party's disobedience of the order was done willfully. So this essentially, he's stating that this case shows that she can make the decision, doesn't even have to just be off the evidence. It can just be based on her being the right person who understands and has knowledge of the parties involved. Is that what that is? If I respectfully, I disagree. That isn't proof. If I wanted to leak something to Brandon, I'd pick someone with a name similar to Brad and act like it was a mistake. Okay, so respectfully, and I totally understand what you're saying. So then my next question is, and once again, we don't have the contempt transcript, so I can only go off of what the compilation of what people who were in court said. So please understand that that's what my next question is coming from. From my understanding, there was an email that was shown that Baldwin had sent to Brandon Woodhouse stating that email was not meant for you, please delete it. And from my understanding, it was within an hour of him sending the original email. Does that change anything, Lauren? And like I said, you can absolutely disagree with me. I'm totally okay with it. So I mean, I think that if it was maybe just one, I could probably see that, okay, yeah, that would make sense. Like we're just going to pretend like this is going to Brad. Like, yeah, that's still not proof. Think our middle school kids would pull things like that. and say, hey, delete it after. Okay, so then my next question to you then would become, because it's the totality of the evidence that's presented. So let's talk about this then. The next question I have is that Hennessy had 3 lawyers take the stand who all have stated that they have misdirected emails at one time or another. And he also asked them what they would do about it if they had, when they did misdirect emails. He had, I believe it was 8, and don't quote me on that number, but I believe it was 8 affidavits from other attorneys that all stated that they had misdirected emails at one point. I really wish that Hennessy had asked, like Holman when he was on the stand, have you ever misdirected an email? I'd love to know the answer to that. So, I mean, like I said, yeah, respect. You can have your opinion all you want to. I just don't agree. I think looking at all of that, it doesn't make sense to me that he would intentionally send anything to Brandon Woodhouse. Yeah, if I snuck out and nearly got caught, I'd make sure my mom heard me telling a friend, I can't believe she thinks I did that. But that's when you're a teenager, no? I mean, we're not teenagers anymore. Yeah, that's why I said you're fine. You can absolutely disagree. I'm good with it. I could see it happening. I mean, I don't see that there's any proof that it was done intentionally, in my opinion. So once again, my opinion is just here for YouTube. I don't get to make the decision ultimately. And this is why I don't care what people's opinions are. As long as they're not being jackasses, I don't care. Because none of us are going to make this decision. So at the end of this, we could sit here and just fight with each other about our opinions and what we think. But ultimately, we don't get to make the choice. Like Judge Gull is going to decide what Judge Gull wants to decide. And whatever we say here on YouTube is not going to impact her in the slightest. She just isn't going to give a shit what we think. So I'm not going to waste my energy. And this is why I tell you guys, you don't need to fight with anybody if they have a different opinion, because you're only causing yourself harm. You're only causing yourself distress. It's just not worth it. It really isn't. And that's the same when it comes to the trial. Like, we can sit here and talk about what we think of Richard Allen's innocence or what we think of Richard Allen's guilt, and ain't one of us going to be on that jury. So, I mean, at the end of the day, like I said, I just don't like people being assholes. Right. And all of us are just our opinions. I don't think you're being disrespectful. No, and I don't think that's what she's saying. I think she's saying what I'm saying. I don't think that was to you, Lauren. That's my thought. She doesn't normally care what anybody thinks. Okay, let me see what else there is. Okay, so essentially he's telling her, like, hey, the court can kind of make the decision because they're the best person to know and understand the parties at play. If the court finds a party in contempt, the court can sanction that party. The purpose of the sentence imposed, which the state refers to as a sanction, is to vindicate the authority of the trial court and not to punish for the commission of a criminal act, as defined by Indiana legislature and codified in the criminal code. In this case, there is indirect contempt by the defense. The state has presented evidence from which the court can find that the defense intended to leak the information from discovery, which is a violation of the gag order. I don't know where that they intended to leak the information. I do not see proof of that. I don't see proof of that. I don't see any intent from discovery, which is a violation of the gag order and the protective order. The court has witnessed many of the violations that the state presented at the hearing on March 18th, 2024, that in conjunction with the exhibits, that were submitted into evidence meet the burden of the contemptuous conduct on the part of the defense. The sanctions for said contempt are left to the court, but should ensure that this type of conduct does not occur again by the defense. Okay. So is it like a slap on the wrist, don't do it again? You're held in contempt, and it's like a little knock, like, you know, on your record, just so that they don't do it again. And then if something else happens, then what? Like, now it's just, now there's, that would be a huge conspiracy. All right, let me see what you guys think. So that is signed by Nick McClelland. I don't agree with a lot of it. And go back one at a time. That the gag order was not in effect when the press release happened, nor was it in effect when he released his press release. The second one, if there's no intent to accidentally send this email to Brandon Woodhouse, then there's no intent, which means no contempt. And then for the third one, when it comes to the crime scene photos, I guess my biggest question is going to come down to that one sentence. Did that actually happen? Is there actually some type of proof of that actually backs up what Nick is saying? Where was that? Let me see. I can't believe that this is now in a filing. This actually hurts my heart a lot. Where was I going? Oh, I was looking for that. Decisions that have been changed the story. The stolen discovery that he went in and he broke in. Why can I not find that? Oh, here. That Andy encourages Mitch Westerman to reach out to the media and push their narrative. That right there. I'm very curious about that. There is no proof the photos were intentionally leaked. Nick hasn't proved any of his accusations. That's where I'm at. If there's something like this, and like I said, nobody that was in court said anything like this on any of their recaps. If there's something like this, I would be curious the context, one, and then I may very well side with him if he's like, hey, take all this and run it to the media and do XYZ. You know, and there's an exchange of discovery items like the crime scene photos or even the F tree, anything like that. And it's like, hey, take this and push it out to the public. I mean, that might alter my entire belief, but nobody has said this. So, and then him exaggerating up here on multiple occasions makes me go, is this even true? Is this true? I can't trust it. You know, I guarantee that's going to be a huge thing. Andy encouraged Mitch Westerman to reach out to the media. And look, Andy's already talking to Dateline. Gosh, these idiots everywhere on YouTube thinking that Nick McClelland's lying. Look. I can hear it now. Yeah, pushing the defense narrative as a general statement isn't a violation. Right. But in these messages, is he sending like, hey, Mitch, here's the F tree pic. Get it out to the public so we can, you know, see what happens. I may have a much bigger issue than I feel right now. But this is a very general statement. This is, you know, and I don't trust it. And I always tell you guys, like, this whole thing comes down to trust. And I don't trust it because we know he's exaggerating other shit that was already proven to be incorrect. The voiceover. All of this is out of control. Something's going to snap soon, in my opinion. Justice can only be spit on so many times in the spotlight until a big hammer comes down. Well, what if I have an explanation for why my spit is there? Does that make it okay, digital? But my understanding was that was between Fortson and Westerman. No proof of that between Baldwin and anybody. Ooh, TT. Okay. In other messages, Andy encourages Mitch Westerman to reach out to the media and push their narrative. Okay. So let's see. Hey, Stevie Irwin. If this is... Okay, so when they said they got the screenshots from the iCloud account of Mitch Westerman, the screenshots are text messages between Mitch Westerman and Andy. Okay, so Mitch Westerman is taking screenshots of his conversation with Andrew Baldwin. And do we even know who he actually sent them to? Because if they only have his iCloud account, do they know? Because remember, they couldn't get into his phone. They said it was going to take years to get into his phone. If Baldwin has been an attorney with no issues for 25 plus years, there's no reason to believe he would purposefully leak anything. I would think that you'd want some absolute proof to try to go around just trashing everybody's reputations on this. This would require another hearing to present this. Too bad he brings it up after the fact. Okay, so this is what I'm thinking. They do have in the exhibits that were presented, they have these screenshots that they found in Mitch Westerman's iCloud account. So is he talking about the screenshots and or is this what Mitch West... They don't have anything between Mitch Westerman, right? They don't have anything from Mitch Westerman to Fortson, which is why they couldn't even actually prove that Westerman was the one who sent him to Fortson, because they don't have Fortson's phone, and they don't have... I mean, they have it, I think, but they didn't have access to it. They don't have all the info from Fortson's phone, and they don't have all the info from Mitch Westerman's phone. What they actually had was the screenshots between Fortson and Cohen, and then they have these screenshots they found in Mitch Westerman's iCloud account, and that was it, right? I don't remember them saying he sent screenshots to anyone, but screenshots were of convos between Westerman and Baldwin. My understanding was there was no proof of Baldwin saying that to anyone. Ooh. So then this very well might be another exaggeration. I don't know. Andy and Brad look straight out of Law and Order, so I trust them. I'm a simple man. Nick hasn't shown any proof of messages between Andy and Westerman. Nick is getting the players mixed up. In towns of Monticello and Delphi, I'm hearing mixed opinions. Most do question if they have the correct guy, but some leave it up to the law. That's why I think it comes down to trust. I will always say that. People who trust and believe in these investigators and believe in Nick McClelland are going to just go that this is the right thing. And then those that don't trust Nick and do trust, like Baldwin and Rosie, or even Hennessy added in now, if you have more faith in them, then you kind of take that side. The first sentence in that paragraph is an incomplete sentence. Why do you think it's an exaggeration if he states there are messages between Westerman and Baldwin? This one right here, this is because that's what my question to people who are in court is, was this actually... I'm going to preface this again, and I will say, we do not have the transcripts from the contempt proceeding. I can only go off of what we have compiled from people who were in the courtroom and have come forward and said what they heard. That's the only information we know until we figure out if we're going to get the contempt transcript or not. So you have to know that I'm basing my opinion off of that. We do know that they had screenshots from Mitch Westerman's iCloud. They could not get into Mitch Westerman's phone. They said it would take like 2 years to get into it. they find these screenshots that are between Mitch Westerman and quote unquote Andy. So he says here that there's a lot of text, or a lot of screenshots, but you can clearly see that Andy is Andrew Baldwin. And in the text, Andy talks about writing the Franks memo and how it is a huge endeavor on his part. In other messages, Andy encourages Mitch Westerman to reach out to the media and push their narrative. Is my question to the people that were there, is this something that was talked about in court? Because if they cannot prove that Westerman actually talked to Fortson, can they prove that Mitch was actually reaching out to any media sources? Is Andy encouraging him like, oh, I wonder what the public's going to think of this, ha ha ha? Or is it, hey, Mitch, put this out, reach out to WTHR and make sure that they have it? Like, I want to know more about this, but because this is not something that was ever directly talked about from any of the people that were in the courtroom, I don't know what it means. This is why I'm stuck on it. I think Andy's probably the name that was in the phone. And that's a separate question. So then that's the big part, is Baldwin and Rosie going to go after Nick for some type of, and I don't even know what it would actually be under, but for something to do with the fact that he's looking at the defense's work product. We don't even have a phone number that it comes from because it's just a screenshot. They don't have a download of anybody's phones. They literally have screenshots. Like, it's the craziest thing. I feel like it's social media court. Like, that's what, like, we would take. Well, like, I have a screenshot of so-and-so saying such and such, and I'm going to take it to court. You know what I mean? Like, it's such a social media thing. They don't, like, law enforcement, you have the ability to download people's phones, get the Celebrite reports, figure out who the hell their people are talking to. But no, they don't have any of it. I think that if you could save criminality's contact in your iPhone with the name Mother Teresa, iCloud would show the exchange between me and Mother Teresa. If you screenshot our conversation, that's exactly what I think. Interesting how the screenshots exist in the iCloud and they can't get into his phone. Sounds staged. Well, I think he's not allowing them in his phone, and his attorneys have probably fought it. You know, he's not willingly letting them in. And so for like a subpoena, they're like, it's going to take 2 years to crack into that dude's phone. Let me see. I want to see the fucking messages. Where's the exhibits? I know, that's where I'm at. I'm like, okay, do we see Andrew Baldwin telling Mitch Westerman, here is the F tree, send it out, get it out to the public, and let's see what they think about it. If that is said, if that is what is said, that is a big deal. But that's not what, I mean, that's like, Andy encouraged, why not give me the message in quotes here or something? You know, in one of the screenshots, Andy states verbatim what Andy said. That makes me go, is this exaggerated? Somebody was asking like why I said it was exaggerated. Now I know where I'm at. But because why not just state what he said? Why not just say it? Could have figured this out even though Diener thinks he's too dumb to read a Celebrite report. Well, I don't think they wanted that in there because, as we now know, Patrick Westphal deleted everything off of his phone or got a new phone. Outright covering up. What about Professor Turco? What about loss of tapes, recordings? What about the deaths, murder surrounding the entire case? I know. As I said, if you take everything in its totality, it's a lot to just go, this is just a mistake. Anything proving actual willfulness should have been showcased. It's exactly, Lorna. That's what I'm like. Why didn't you just type out the message? What does it say? Does it not actually say that? I know. Civil cases and screenshots. But I'm like, you could download the dude's phone. You could have subpoenaed the person you have the screenshots of. You could have subpoenaed them and made them be there for court. You can fake screenshots. There's apps where you can literally just go fake screenshots. Does Hennessy's exhibits last week have this group of wording? His exhibits, the appendix, you mean? The appendix that he put out? Let me see if I can grab the appendix real quick. Oh, I'm way too far down. Hold on. Let me go back up here. Oh, the other thing that we had filed today by the defense was another ex parte for funds, similar to what was filed the last time that Nick saw and then wrote about. Let me see. Here's the appendix. I don't recall anything like that being in there. Well, I mean, he's not going to put that in there if it is. So, I mean, let's be real. I don't think he's going to. Message from Holman where he contacts Woodhouse. Let's see. So the appendix is really just about the conversations in the screenshots between. Well, you know what? Maybe it's not. I thought it was just the messages between Fortson and Cohen. Is this? It's true, Christy. If they can stage a crime scene, they can handle a screenshot. And they do. They absolutely do. Deets. Yeah, you know it. Now, I am believing Westerman did it to prove a point to Fortson and things got out of hand. That's what I think. That is my personal opinion, is that Fortson was pro Richard Allen is the right guy. And you have Westerman who has access to all of this stuff and doesn't, he's more on the defense side of that Richard Allen's not the right guy. So I feel like he was doing these, sharing this stuff and taking these photos to prove to his buddy of many years that he was wrong. Like, Westerman's like, I'm right, you're wrong, and I'm going to prove it to you. And that's what I think happened. Now, I can't prove that, but that's what I think happened. Right. Okay. So MRC had many screenshots, but none from Fortson of combos between him and Westerman or Baldwin. So they have nothing from Fortson between Westerman and Fortson. They have nothing between Baldwin and Fortson. And they only have these screenshots. We have no idea the context or even the order they belong in, or if they have all of them, to know what it is. And I just wish he would have just quoted it. Quote what he said so we know what he said. If he said, Mitch, take this F tree and send it to Court TV, or hey, work with your buddies and get this out to the internet so they can see it, then I'm on board. You got me. I'm on board, but I don't see that. And why not just quote it? But I don't think there's anything in here that talks about that. Screenshot of a screenshot printed on paper, then cropped. This is still interesting to me, this 3/20/18 stuff. Message from Holman where he contacts Woodhouse. I think this is just their conversation. This is just like a Hennessy version of the conversations between Fortson and Cohen. A series of pictures not related to the defense. It is obvious pictures of this stuff and not originals. Talking shit about Nick. I don't think so. And let me go to his. This is his post-hearing memorandum. Let me just look and see Westerman. State's Exhibit 5 consisted of the 5 pictures which the state... So this is Hennessy's from last week. They're estimated Fortson after receiving them from Westerman. Okay. Sergeant Holman testified that he believed he had seen them at the deposition. Mr. Rosie testified that he reviewed the deposition exhibits and compared them to the 5 photographs rather than rely on memory alone. He then testified without contradiction that 2 of the photos were not created or used by the defense. Thus, those 2 could not have come from Westerman. To the extent they may have come from Fortson, he had many other sources, as confirmed by State's Exhibit 6, which was 143 pages of Fortson's communications. Okay, what else is there about Westerman? Not once did Fortson identify Westerman as his source. We talked about that a little bit ago. He never names him. Not once did he describe any direct contact with Andrew Baldwin. Not in person, not by phone, or any messaging application. So that's Fortson's phone. Doesn't have any contact. He never identifies Westerman in the communications between him and Cohen. And there is no sign of direct communication that Fortson is in contact with Baldwin personally. The state ignored Westerman's ties. Okay, I don't care about that. Exhibit 9 is Westerman's affidavit, which clearly establishes that what he did was not known by Baldwin and that Mr. Baldwin did not participate. He admitted that what he did was without any authorization whatsoever. So that's did Westerman have a hearing today? I don't know. I can look. I don't know. I don't remember his off the top of my head. I constantly have to go back and check his. The state alleged that the person was Mr. Westerman. Okay, so State's Exhibit 10 consists of 20 pages of back and forth messages between Mr. Baldwin and an unidentified person. The state alleged that person was Mr. Westerman. Okay, this is where they are. This is what they're talking. So they they find these screenshots in Westerman's iCloud, but they don't actually know if they're from Westerman. Like if Westerman's the guy on the right side of the screenshot, or if they're just in it's in his iCloud. I think that I don't think it's a big leap to suggest that they probably are Westerman screenshots, but State has to prove it. So a state alleged that the person was Mr. Westerman. That exhibit was admitted over objection because it contained Mr. Baldwin's mental impressions and work product and failed to identify the other participant. Mr. McClellan read that exchange, which with advanced knowledge that it was communications regarding consultation on the case. He never should have read it. Okay, 327 hearing for Westerman was canceled. 411 now for Westerman. Okay, thank you guys. Oh, Woodhouse. Did Woodhouse have a hearing today? I don't know. I know that he was actually supposed to go to trial the same day that Richard Allen was supposed to go to trial, and then it got postponed. All right, let me see what else there is. Mr. Baldwin's communications with Westerman and sharing of his Frank's memorandum with him and others for critique is exactly what was contemplated. The prosecution's allegation that Mr. Baldwin's discussions with Westerman violated the gag order is unfounded and not supported by the evidence. And nobody puts in what the damn evidence actually is, so we don't know. We don't know what that screenshot actually says or its context. And apparently, according to Hennessy, there's not even proof that's actually a conversation between Andrew Baldwin and Westerman, because it's just a damn fucking screenshot with somebody named Andy and some unknown person. Now, like I said, I don't think it's a leap to think that it is the two of them, but I don't know why. They could have easily proven that, though. Additionally, Sergeant Holman and Mr. Mullins testified that they were aware that Mr. McClellan was exchanging information with Gary. Okay, that's not the same. Let me see what else there is. It would have been relevant and probative as to whether Mr. Baldwin's discussions with Mr. Westerman were prohibited by any rule or order or were inappropriate in any manner. If Mr. Baldwin is to be held in contempt, Mr. McClellan should face the same scrutiny. Oh, Scott, you're back. Y'all did great acting it out last night. I watched it this morning. Judge Go was extremely rude and vicious to Andy. CJ played a very good goal. We had an awesome Diener too. So we got to do that. We got to do the second part with Amber Holders and Steve Mullins. We got to do that one next. But I don't know. This could go either way. I'm going to sit on the fence on this without some more information, if whether he actually did that or not. But I mean, it's tough because We don't have it. We don't have that. We don't have that proof at all. Woodhouse trial is now scheduled for 7/17. Okay, Woodhouse hearing today confirmed first setting jury trial for same date as RA's. I believe another status conference set in a couple of weeks. Okay. It's telling this supposed text wasn't quoted. Why not just write down the damn text and put it in quotes, right? Like, how easy would that have been to be like, here, this is what he said. I don't know. So this one is this one's Tennessee's, FYI. I think I said that, but just in case. All right. Any other thoughts on this before we wrap this one up? Maybe Westerman is letting Nick make false accusations, and then we'll reveal that Nick is wrong at trial. You think that well, Nick won't be prosecuting Westerman at his jury trial that he's requested for his misdemeanor conversion charge. I don't know if Westerman would even be testifying at any other hearings, except if the defense decides to try to do something to Nick for looking at the work product. I don't know. I don't think so, AH. Not that I've heard. Yeah, Woodhouse's judge. Yeah, Woodhouse's judge is freaking Diener. I think everybody's judge there is Diener, though. And then Nick is the prosecutor. Oh, Criminal Network, thank you very much. I appreciate it. I tried to listen to the last one, got physically on. I've listened to a lot of BS around this case. I'm just checking out what you guys are saying. Nick is still too worried about the contempt instead of focusing on the case. I don't disagree. It's the weirdest thing to me to continue down this path. I mean, I guess once he's in it, he's in it. Like, he has to do this now because he didn't drop it or postpone it. Kyle Stacy and Gabe, one's involved in Delphi and Karina's case, preparing for battle post. And then February 11th, same exact rune left on the tree. What are the chances? And calling themselves blood brothers, and both are practicing Odinism or Norse paganists or whatever. I don't know exactly which one you want to go with, but Baldwin definitely have Mullen testify to things he can prove during trial or lied, in my opinion. Don't start doing that. No, I yawned. How many of you guys yawned? How far did it reach? I think I'm actually yawning because I'm hungry. I need some sustenance. I don't even know if I did, Jenny. I don't even know if I did. I tried. All right. Well, I'm gonna get with Sleuthy and see when she's available to do part 2 of the motion to dismiss. Like I said, we won't have an update about the transcript for the contempt motion until approximately April 8th, and I think we'll make the decision then on whether we feel that we feel like we want it or not. So we'll work that out together. Okay, I got a tiny human. Give me 1 second.
The egg hunt for you and Dad.
Oh, you do?
Yeah.
Oh, okay.
Giant.
Uh-oh. He's got an egg hunt, he said, for us. I don't know what he's done.
Oh yeah, I took the egg.
You took the eggs and made an egg hunt?
Yeah.
Did you fill them with candy or money or anything fun? Or are they just plastic eggs?
Some have something.
Ooh.
Some don't.
Some have something and some don't. I get to do an Easter egg hunt. All right, I'm going to wrap this up. Like I said, I'm going to check with Sleuthy, see when she wants to do part 2, and if she does maybe later tonight or mañana, we'll see what's on her agenda. Thank you guys for being here. Thank you guys for hanging out and listening, and I hope that I helped a little bit explain it. I don't know if I did enough fluffing. If I didn't, maybe you guys can leave me a comment. Let me know that I need to do a little less fluffing or more fluffing, depending on where you fall in that spectrum. I'm open for feedback at any time. Oh, goodness. But I do.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one